The others are come. That's fine. We can start anyway. I can do my recording. So. Let's start.
Okay. The basic topic for today is assistance in collection. How one country may, under certain circumstances, assist in collecting taxes for another country. And I'm going to get into that in a few minutes, but before I do so, I want to update last week's talk, which was based on tax information exchange agreements. Yesterday afternoon, the United States and Liechtenstein signed a significant tax information exchange agreement in Vaduz, the capital of Liechtenstein. There were press releases issued by both the U.S. Treasury Department and by the Liechtenstein government. The Treasury's press release said that this will enable the United States to access information that it needs to enforce U.S. tax laws, including information related to bank accounts in Liechtenstein. It will cover all kinds of federal taxes, as do most of the other tax information exchange agreements, and Liechtenstein would furnish the information whether or not it needs the information for its own tax purposes, and whether or not the conduct being investigated would be criminal under its laws where there's a criminal investigation. If they don't have the information in their possession, they're required under the terms of the agreement to go get it. And there's some language in there that says that requests from, let's say, one country to the other, that is from the United States to Liechtenstein, must be honored even if the information relates to or is held by non-residents. I think you can read Switzerland in particular in this agreement for non-residents. They're going to attempt to get the Liechtenstein government to use whatever influence it has, so that if a bank in Liechtenstein is being asked to provide information, and that information happens to be partially in Switzerland, that bank's going to be required to go get the information if it has the ability to do so. Now, the agreement states that it does not apply for transactions in the past, but that can be, you have to look at that pretty carefully. It's going to relate to tax matters arising in 2009 and years after 2009. But documents or other information created before 2009 can be obtained from Liechtenstein, provided that the request relates to an investigation of a post-2008 year. And there's a notice it points out that in the case of pre-2009 years, the United States can already obtain information regarding criminal tax matters under the existing U.S.-Liechtenstein Mutual Legal Assistance Treaty. There's an appendix to the agreement, and as well as the agreement itself. And incidentally, the agreement is available on the U.S. Treasury website for anybody that wants to see it, as well as in tax analysts and IBFD's websites. But there's a little thing built into the to the appendix. Toward the end of the appendix, it says that if assistance is requested with respect to a taxpayer's bank transactions occurring after December 31st, 2008, and documents such as, not limited to, a signature card for the account in question were executed prior to January 1st, 2009, the parties would exchange the documents. What in effect that means is that if somebody opened an account, let's say 5 years ago, signed a signature card at that time, the IRS will only be able to obtain basic information from Liechtenstein concerning tax years beginning in 2009, which of course starts very soon. But what you have to take into account is that if they can get things like signature cards and perhaps some of the correspondence that relates to the account, they may be able to show that the account was opened 5 years ago, since they can then show to Liechtenstein that and to Switzerland that because almost all transactions in Liechtenstein seem to be handled basically by Swiss banks functioning through with the assistance of Liechtenstein banks. So they'll be able to go because they'll have enough evidence to go under the Swiss U.S. tax treaty and be able to show perhaps that there's tax fraud or the like. For example, they could then go to the person in the the U.S. taxpayer, and say, we have reason to believe that you have had an account in Switzerland for 5 years. Is it true that you had an account? That we know it exists now, but is it true that you had one before? And if the taxpayer denies that, the denial of that when he's asked a specific question about it probably would constitute tax fraud or the like under the Swiss agreement. So I think you're going to see some substantial usage of the Liechtenstein agreement as an adjunct to the Swiss one. And that's all I've got to say about that subject. Now let's move on to today's real subject, which is how some countries help others to collect taxes. And I must say that when I went to law school, and that's quite a while back, the idea that one country would collect unpaid taxes for another was unthinkable. There was a so-called revenue rule that had been around for several hundred years, under which one country does not enforce the revenue laws of another country. It's been around since the 1700s, but it's slowly but surely being eroded by some bilateral and multilateral treaties. I guess we can summarize it by saying that was then and this is now, and now is quite different than what it was. Checking some history, I find that there was an estate tax treaty signed in 1950 by the United States with Greece. And one of the articles in that contained an undertaking by both countries to lend assistance and support to each other in the collection of taxes which were the subject of that treaty. The article generally provided that neither country would assist the other in collecting taxes from its own citizens or from their estates. In 1951, the U.S. Senate approved that treaty, but did so with a reservation in which the U.S. refused to accept that article of the treaty. And the unaccepted article and all references to it were deleted from the treaty by a 1953 protocol and the treaty entered into force without any collection assistance provision. That treaty is still in force today. Someone is saying bad sound. Can you, Professor Byrnes, can you hear me okay? Okay, I'm going to keep going then, I think. Now, what's the situation today with collection assistance provisions? There's been some substantial change, and I think there will be even more substantial change in the future. There are now several countries with which the United States does provide for assistance in collection. Now, there's two types of assistance in collection provisions. The one that is built into the current U.S. model treaty, and probably has been in most of the prior model treaties and in almost all of the existing U.S. tax treaties, was one that in effect said that if the treaty was misused so that it resulted in not sufficient tax being collected that should have been collected under the treaty, the other country will cooperate in doing that. That was the standard provision that appears in that model and in most U.S. treaties. But there are a few treaties today that go much further than that and provide for full assistance in collecting tax claims. The most significant of those is the current treaty between the United States and Canada, in which each of them agrees to collect taxes, and they don't limit their agreement to collecting taxes only to those covered by the treaty, so that in effect, if a taxpayer owes money to the United States, and that taxpayer either moves to Canada or has substantial assets in Canada, the United States can today pass on its revenue claim to the Canadian government, and the Canadians will collect it in pretty much the same way as they would collect a Canadian tax. And I think it applies in general to all U.S. federal taxes, but not to those of states or cities. There are some limitations. The Canada will not assist in collecting a U.S. revenue claim against an individual who was a Canadian citizen when the claim arose, nor will it assist in collecting a claim against a Canadian company. The provision is reciprocal, and the IRS similarly assists Canada in collecting Canadian taxes. When that provision was not always in the treaty. That treaty has been amended, I believe, now 4 or 5 times anyway, and the provision was put in by the 1995 protocol, and when that protocol took effect, which was, I believe, in 1996, it provided that this particular provision, the one for assistance in collecting taxes, would be retroactive for up to 10 years, so that in effect the United States has been able to go to Canada now and collect taxes going all the way back to 1986, unless those are barred now by some statute of limitations. But typically, if somebody moves off someplace else, there may be a tolling of that statute of limitation. That retroactivity, I think, is significant because If we can assume that although the U.S. today only has these types of collection provisions with about a half a dozen countries, and I'll get to those in a few minutes, there's nothing to stop them from adding this to other treaties over a period of time. And I'm going to predict right now that the U.S. will expand it probably during the next year or two, and I think they're likely to pick up these provisions in treaties with Australia, New Zealand, and UK, in addition to others, and possibly extend it to the entire European Union. These are at least things that I'm sure a money-hungry Congress is going to consider, and a money-hungry Treasury is going to consider in the next year or two. And since Canada won't collect taxes, what happens if somebody moves from the United States to Canada and after a period of 3 or 4 years becomes a Canadian citizen? Well, let's take an example of someone who moves to Canada, let's say moved to Canada in 2007, and that he or she becomes a Canadian citizen in 2011. Well, Canada will assist the IRS in collecting all U.S. federal taxes due prior to 2011. And if that person dies before becoming a Canadian citizen, Canada will almost certainly also assist the IRS in collecting estate tax, the U.S. estate tax. On top of that, they may take the position that they may certainly take the position that the estate tax would apply to U.S. property, or based on citizenship to all property, and they might even take the position that this taxpayer was domiciled in America at some time, at the time he or she died, and that the estate was therefore liable for full U.S. estate tax on worldwide assets. So any American who moves, any citizen or former citizen who moves to Canada today has to take this kind of thing into account, that the IRS may continue to go after taxes, certainly up to the day that he or she becomes a Canadian citizen, and possibly even after that based on an alleged domicile. Now that provision, as I noted before, is not unique. It does exist in a few other U.S. treaties already. I believe these strong assistance and collection provisions apply under current treaties with Denmark, France, the Netherlands, and Sweden. And there may be others. Canada also has broad collection assistance provisions in 3 or 4 of its treaties, at least those with Germany, the Netherlands, and Norway. Now, there is this the OECD model now has substantially changed the assistance in collection provision, and about 5 or 6 years ago, the model was updated, and a new Article 27 was inserted into the OECD model entitled Assistance in Collection of Taxes. That article is extremely broad and would even cover taxes imposed on persons and taxes not covered by the treaty. Now, not all countries will agree to assist everyone in collecting taxes. Some countries may have constitutional problems in doing so, but others seem to be quite willing to enter into broad reciprocal agreements to collect taxes for other countries. The OECD Commentary, which was, as I say, amended in about probably 2002 or 3, was republished this year under the 2008 model, and several articles were updated. I don't think this one was. I think this article was kept the way it had been since about 2002 or thereabouts. But it now provides for a provision for broad assistance similar to the type that I mentioned before for Canada. But the commentary does point out that not all countries will want to do that, and some may prefer to provide more limited assistance. There have been some new developments this year, and last year and this year, in this area. For example, Australia and New Zealand included this comprehensive assistance in collection article, virtually the same as that of the OECD model, in their November 2005 protocol to their income tax treaty, and that protocol generally took effect in 2007. But I just 8, in which both countries issued press releases saying that they had now put together everything necessary to make that provision effective, and that they exchanged diplomatic notes in September, that's a couple of months ago, showing that they had completed their relevant internal procedures required to bring this into force. So New Zealand and Australia now will collect taxes for each other. And I also came across an amendment to the treaty, or a protocol amending the treaty between New Zealand and the United Kingdom. And that one also contains now a broad assistance and collection provision. I think you can assume that both Australia and New Zealand are going to go around asking everybody to sign, which is something that the Dutch and some other governments have been doing for years. But there's going to be this wave into of these types of developments. The situation in other countries is that there's now a European Union directive that requires every member country to assist all other member countries in the recovery of tax claims for various taxes, including income tax. And an instrument permitting enforcement of unpaid income tax claim in the taxing country is automatically treated as though it were an instrument of the country that is asked to collect the tax. So you now have 27 countries, each of which have agreed to exchange, to collect taxes for each other. You can also look to various parts of the world where groups of countries have banded together and done something similar. The 1989 treaty between the Nordic countries, mutual administrative assistance in tax matters, contains very broad collection assistance provisions. And that treaty now applies to Denmark, the Faroe Islands, Greenland, Finland, Iceland, Norway, and Sweden. and it generally provides that decisions in tax matters in any of these countries are enforceable in any of the other countries. And some of these Nordic countries have now also included similar collection assistance provisions in their treaties with other countries, including done it with the United States. Some other countries that have broad collection assistance provisions in at least some of their treaties are France, the Netherlands, Estonia, Latvia, Lithuania, and they have those with several other countries, including all the Nordic countries, and also with Belgium, the Netherlands. The Netherlands keeps adding new ones all the time. They have broad collection assistance provisions in their treaties with Belgium, Canada, Denmark, Estonia, Finland, Latvia, Lithuania, Norway, Poland, Portugal, South Africa, Sweden, Ukraine, the U.S., and brand new, the UK. So, I mean, it looks like they're out to get those kinds of provisions eventually from everyone. The Dutch Model Income Tax Treaty contains an article entitled Assistance in Recovery, in which each country agrees to collect in accordance with its own laws and administrative practices tax claims based on taxes covered by the treaty. There's one interesting provision in the article which states that such claims cannot be recovered by imprisonment for debt of the debtor. I guess we should be thankful for that. I think that's a little bit more extreme than most of the others. And finally, there's this mutual assistance treaty that is now open for signature by all of the members of the Council of Europe and the members of the OECD who are not members of the Council of Europe. I think that amounts to a total of about 54 countries. That treaty was signed about 20 years ago and has slowly expanded the number of countries that have signed it. And I went on the Council of Europe website and found that they list there all of the countries who have signed it, whether or not they have ratified it. They do that with all Council of Europe agreements. This one, I believe, when you get to the Council of Europe website, is number 127. If you go to treaty number 127 on the Council of Europe website, you will find information, probably the text and the list of ratifications on there. As of last count, that treaty is in force as to 13 countries, and 3 others have signed it, but it's not yet in force as to them. The 13 that have the treaty already: Azerbaijan, Belgium, Denmark, Finland, France, Iceland, Italy, the Netherlands, Norway, Poland, Sweden, the UK, which it just took effect this year, and the United States. The United States when it ratified that treaty, chose to exclude the collection assistance provisions. That means that the United States will use or may use the exchange of information provisions of that treaty, but will not apply the collection assistance provisions. I caution you that that might change. This is hypothetical on my part, but again, because of changes that are obviously going to take place with a new administration, it's entirely possible that the U.S. Senate might reconsider and permit an amendment to the U.S. reservation to be made, which would change that and perhaps apply these kinds of provisions to some or all countries.
Marshall, sorry. Which one was that? Which treaty?
That's the Council of Europe OECD Mutual Assistance Treaty.
Okay.
It's
Got it.
Got it.
The official title is the Convention on Mutual Tax Matters. It was signed 20 years ago, and the OECD published this book in September, I believe, honoring the 20th anniversary of that. So if you go to the OECD bookstore, you can buy this book, which runs about 130 pages, which contains the full text of the treaty and the full text of nations that have been entered in connection with that. The United States did extend this treaty to cover Puerto Rico, the Virgin Islands, Guam, American Banana Islands. Denmark originally extended it only to Greenland, but they amended their reservation last year to extend it also to the Faroe Islands. The Netherlands extended the treaty to Aruba and the Netherlands Antilles, and France has extended it to all of its overseas departments. Now, what about the United States? Could it go to one of these other countries and say, well, you've agreed to collect taxes in general, even though we don't collect them, we're asking you to collect for us? I think the answer to that is no. They could ask, but the other country could certainly decline. There's a specific there in the treaty itself, buried way in the back of it, that says that if a country enters a reservation, it cannot require another country to do that as to which it has entered that reservation. What if a tax is due but not yet fully reduced to a tax claim? Well, the treaty, the OECD, the Council of Europe OECD treaty does that would be taken while the claim is pending and being contested, and prior to it being reduced to judgment. We still have a few minutes left, and I want to cover another thing that's really related to this. I mentioned at the outset that somebody's asking if there's a PowerPoint. I generally claim the senior citizen's exemption from using PowerPoint, but there was an article or a column I did 2 years ago in Offshore Investment on this subject. And what I'm telling you today is an updated, a very much updated version of that. But I think Professor Byrnes can make that article, that column, available. It was done in, I think, 2006. And if you don't have it, I can get it for you. I mentioned at the very outset that when I went to law school, we had this revenue ruling, and it was pretty strictly enforced in those days. One country just didn't collect taxes in any way, shape, or form for another. That rule is technically sort of still alive, but it has been eroded not only by the various bilateral and multilateral treaties that I've been discussing, but also by a 2005 U.S. Supreme Court decision in the case of Pasquantino, Pasquantino, Pasquantino versus the United States. And the citation for that is 544 U.S. 349. It seems to be a significant case affecting the treatment of individuals who are accused of evading another country's tax laws. By a 5-4 decision, the Supreme Court held, it's the U.S. Supreme Court upheld, the conviction of the defendants for violating America's wire fraud statute by using telephone calls between New York and Maryland in connection with a scheme to smuggle liquor from the United States into Canada without paying Canada's high tax on imported alcohol. The court held that Canada's right to uncollected tax was property within the meaning of the wire fraud statute. And the court said that this was a prosecution to punish domestic criminal conduct, not a suit by Canada to recover a foreign tax liability. I talk about this case because this was apparently the first time that the U.S. Supreme Court held that involvement in a scheme to evade foreign taxes may be an American crime. Discussions right after that case came out with one of our colleagues in Miami, Bob Hudson of Baker and McKenzie, and he suggested the possibility that international tax advisors who assist clients to hide funds from foreign tax authorities by using phone calls or wire transfers may be committing a federal crime subject to substantial penalties, including possible imprisonment. It seems that some things that heretofore have been reviewed as legitimate planning activities may now attract problems if the principal purpose of the planning is illegally evading the proper reporting of taxable income in another country. I think I'll end there and throw it open for questions that you may have asked already that I didn't see on the chat line, or that you may want to ask now using the chat line, and Dean Byrnes will fire away on those. Thank you.
Thank you very
kindly,
Prof. Langer,
and I'm looking through the chat again.
Okay, who has
questions? You can open them up.
I see Oscar's
comment, which is
a collection assistance
priority
among countries.
Should be a priority among countries given projected budget deficits after global bailout efforts.
I know that Germany just added another $56 billion this weekend. The United States, nobody knows for sure, is somewhere between 1.5 and 2 trillion. And you have to add another trillion
for the projected infrastructure. plan of the new administration. Is there that much tax out there to be collected?
Is the tax gap, the international tax gap
real?
Nobody knows what it really is. It's real, I'm sure, but whether the amounts that they come up with, that Jack Blum comes up with in reality, is entirely another question. I think that what we're going to see here, there was some interesting wording in I went back and looked at the U.S. Senate report on the Canadian protocol, the one that I talked about before, that provided for this assistance in collection. And it said at that time, in the report approving the treaty or that protocol, it said that the Senate Foreign Relations Committee believed that because of special and unusually compatible relationship between the U.S. and Canada, inclusion of such a provision was justified. It added that inclusion of this provision in the Canadian protocol might lead to increased interest in the inclusion of similar provisions in protocols or treaties with other governments. And what the Senate said was that in each instance, consideration may need to be given as to whether it is appropriate for the United States to assist in the collection of another government's taxes. I think what we're going to see is that, yes, they will apply that kind of a rule, but they'll do it with more and more countries, and I can foresee the United States doing these kinds of provisions with places such as Australia, New Zealand, Germany has these kinds of provisions with France and the Netherlands and Sweden, and possibly some of the other European Union countries and some of the other I'm not sure that they're ready to do it yet to most countries in like Latin America, with the possible exception of Mexico. That would not surprise me too much, but I think most of the others would, and I don't think they're ready to do this with a lot of the with some limited exceptions. That's something else.
Does anyone in the class remember how much UBS testified in terms of billions of dollars? It was 20,000 Americans. They said that they had illegal accounts that were unreported accounts. But how much was in there?
I think it was 20,000 altogether accounts. But I think they're taking the position that some of those, or many of those, are legally reported. They just, they're not always sure, I guess, is the answer to that.
No. Here's the New York Times that has found it. 20 billion in assets that the IRS says they have dodged up to $300 million taxes.
Now, isn't the amount of the gap
when Bloom justifies in Congress?
Isn't he saying that the gap
is like 100 or 150 billion
of uncollected tax?
He comes up with whatever number they want, I think.
Well, I'm looking at
the.
Okay, so we got the
New York Times.
Well, but of course they made a change. Last week they announced that, Dean Byrnes, last week there was an announcement, or by somebody, that the IRS is now extending this not just to UBS but also to Credit Suisse and also to in London. And to today's tax notes, I think it's today's World Tax Analyst thing, the daily one. You'll find that I believe the IRS Commissioner Schulman gave a speech today where he talks about some of this and says that this is going to be one of their prime projects now to do this kind of thing.
I'm going in right now.
Okay.
I think it's very interesting.
I think.
I wish
there was a really good economics article
that went over the truth, like calculated the actual tax gap.
Because I don't think you can calculate it. That's why they can make up figures, any kind of figures they want.
The government obviously has a legitimate interest in shrinking the tax gap. The question is the use of resources, bang for the dollar
spent.
And the tax gap domestically is, by example,
let's just pick the number 100.
The tax gap
internationally is a 10.
And we spent 2 to
collected 10.
But we could spend 4
to collect 100. Then obviously
you get a much bigger bang.
For your
domestically.
Or spent domestically.
Well, except that I believe the position is being taken today by various people, including. Actually, there was also something interesting today where the Pope issued some kind of a paper. I didn't have a chance to read the details on that, but Pope Benedict issued something the Vatican did, based on his statements that the entire problems with the economy is due to tax havens. Take a look. Stuff up. I just didn't have time to read any of this stuff carefully because it's so early.
That's pretty
coming from
the
yeah, well, that was
Vatican itself.
There was some comments about that too, because the fact that they're claiming that the poor people of the world are suffering terribly because of that, and yet, of course, they've got tax exemption on every church and every piece of property they own, and nobody in the Vatican pays anything to anybody by way of taxes.
Yeah, I'm a big believer that religious institutions should be taxable.
I don't think
there's a argument for exemption.
They're just another citizen of the society.
Well, you're going to have a hard time pushing that one through. But what you won't have a hard time doing, and if I got the gist of what Commissioner Schulman said, primarily to the international area, and that one of the reasons they're doing so is because Senator, now President-elect Obama, is one of the co-sponsors of the Stop Tax Haven Abuse Act, and they expect that thing to go sailing through. Now, that's a horrendous piece of proposed legislation because of the poor way it was drafted, but they'll have time to clean it up a little bit before they actually try to enact it. One of the problems they had is they had a list of countries there. It was put together by some staffers who I suspect had to go find something that they could use by way of a tax haven list. And from the best information I have, what they chose was an informal list that had been put together by the IRS own internal purpose. Well, a lot of changes have occurred since 1984, and many of the countries on that Stop Haven Tax Act list are countries that are very cooperative and have been on the list. And those countries are rather annoyed. They've had to go out and hire lobbyists to go establish to the satisfaction of somebody that they shouldn't be on the list. Nobody's attacking the overall idea, though, of not having some kind of nasty legislation dealing with uncooperative tax havens. If you go back far enough and you read the Gordon report that was put out by Richard Gordon back in 1981, I was special assistant to the IRS and the Treasury at that time, and he had a list of nasty things that could be done to uncooperative tax havens, like stopping flights going from the United States to and from those countries, and stopping wire transfers going to and from those countries. I mean, so you don't know what they're capable of doing.
Well, I think.
Did you find that thing from Commissioner Schulman?
No, but I see something else which reminds me of tax gap. The tax gap and what's going to get very scary for us. So internationally, I just don't believe that the tax gap is very large. I believe it's a maximum $10 billion. I think that's stretching it, because if UBS, which represents a significant portion of the international wealth management market, they have up to $300 million in unpaid taxes for 20,000 clients, which is realistic because most clients have capital gains, and if they were onshore, they would only be paying 15%. And in fact, on a go-forward basis, from everything I've heard from people complaining, they'd all be taking massive losses this past year, this year, and
yeah.
So wiping out a lot of gains. But I mean, if UBS represents, let's say 5% of the marketplace, being the largest player in the marketplace, well, you just extrapolate, and you're at $6 billion. You're at $6 billion of uncollected tax. That's the tax gap. It's not 50 or 100. 50 or 100 or 150 billion, as you hear in Congress a lot. It's not going to solve any problems.
I think they want to go after this stuff for other reasons too, though. I think they see this as something that causes the rest of the tax gap. They see that there's too many stories about people getting away with things, and by going overseas, and the little guy starts on his own taxes. The idea that everybody's doing it. So what they can do with the international stuff is get a lot of publicity on everything they come up with, and you know, they're not picking on U.S. banks when they do that. They're picking on foreigners. It goes back to the old saying. I guess it was don't tax you, don't tax me, tax the guy behind the tree. And the kind of thing where you make a spectacle of those nasty foreign banks that are helping Americans to cheat, and I don't think it matters to them whether in reality whether it's $10 or 10 to something, and make and show that they're doing something.
Well, here I'm reading in today's one of Bush's pardons, and it's about Kerry Heights. I don't know who he is, but he just got pardoned. He was convicted in 1996.
He was convicted in 1996. Sentenced to 3 years probation.
180 days of home confinement.
180 days of home confinement for tax evasion.
Right.
He had to pay $13,000
He had to pay $13,000 fine. This is what he did.
He was respected businessman.
He was respected businessman, like a lot of them.
His attorney saying
that he's represented in the past.
He spent
corporate funds for expenses
that were deducted. But it turns out the
deductions weren't probably all deductible.
Okay, and he had a chemical company. Now this is chemical manufacturing company, it says.
Mm-hmm.
Now that would be part of a tax gap.
That would be part of a tax gap. Say that people are taking illegitimate deductions.
But this goes back to
when they prosecuted the hotel magnate.
It was Helmsley, right?
Leona Helmsley, yes.
Right.
Now
you
have to figure. She didn't do her taxes.
She has an accountant.
An accountancy firm,
and an audit firm. They do her
taxes for her.
She doesn't have
one or two receipts for deduction.
She has a few thousand. Now, unless they know for the accountant walks in and says, "You can't take this as a deduction," and she says, "Screw it, do it anyway." So that's clearly a violation.
Yeah.
But probably like
most Americans,
she takes a handful of
receipts.
She has a receipt. She brings them down to the corner store. In her case, she gives them to the accountant, to the bookkeeper. The bookkeeper gives them to the accountant. The accountant gives them to the accountancy firm.
Some junior sits there and has them all up.
They bring it back to her.
This is what you do. She says, "Wow, all right." She writes a check. She turns it over.
Yeah. Well,
I don't know people who actually sit there
and look at each of their receipts.
Problems with the current system is the massive paperwork that's required to do a return. I never used to like dealing with trusts because if I had to read a 50 or 60 page trust from cover to cover, it was a sure cure for insomnia. I mean, it put me to sleep. And I got the same feeling basically with some of these long pages. You turn pages. There's a bunch of proposals floating around, and I want to call your attention to one specifically, which I picked in yesterday's tax notes. I didn't know about it before, but it's been around for a while. Now, this was in the magazine, which is on the tax analyst website, and I want you to go to Tax Notes, December 8, 2008, pages 1152 and 1150. While you're doing it, I've got a little bit of a summary here of what that's all about. What caught my attention was...
I just found the one on HSBC, by the way.
Oh, okay. Well, that can wait. I think anybody can check that later. There's a senator, a Democratic senator from Oregon, Ron Wyden, and for years he's been trying to persuade his colleagues to take up tax reform, and he's not terribly successful. But he introduced and reintroduced a bill in 2007, co-sponsor, and it's the co-sponsor that makes this thing interesting. Co-sponsor is Representative Rahm Emanuel, Democrat of Illinois, who of course has just been named as President-elect Obama's chief of staff. Now here's the guy who's probably going to read or edit the proposed budget messages, the State of the Union message, and all the rest of the stuff. And he's making this thing. It's called the Fair Flat Tax. It's part of an annual's agenda, I'm sure that Obama was quite aware of this when he named Emanuel. And it's possible that this is going to see the light of day. Look at, because I don't pay attention to proposed legislation. But when it's proposed by somebody who's going to be in that kind of power, I think it's worth looking at it. It's just a couple of page summary here, and I went to Rahm Emanuel's website, and the website seems to say pretty much the same thing as this two-page summary, so that's really all you have to read. But he's talking about three rates, 15, 25, and 35%, substantially increasing the standard deduction so that more and more people will take that, allowing certain things, getting down to like a one- or two-page tax return for most people, abandoning the alternative minimum tax. One of the problems with it, of course, is that everything would be taxed at the 15, 25, and 35, including capital gains. But what he does do that's interesting is I think he allows a deduction for dividends as well as interest on the part of corporations. So you end up with a 35 perhaps on dividends rather than today's 15, but it in effect replaces the corporate tax. If you take today's 15 and add to it the fact that most companies had to pay 35 federal and another 5 state before that, you've got a much higher tax. So actually it kind of balances out. I think there's some things in this. Obviously, none of these proposals ever go through in exactly this form, but I think you're going to see some movement in that direction. I wanted to add just one more thing on today's topic to call your attention to, and that is that if you go to the OECD website, you will find that there's some mention of an OECD manual on assistance in the collection of taxes. And there's a press release, and if you click on various parts of the press release, you find that there is a manual dealing with this, explaining some of this, explaining how it works or how it should work. And if you get into these kind of problems, it's another thing you should be looking at.
I found the article.
I found the article with the
it began. Okay, you're ready.
proposals.
Yeah, from
Matt
Campbell.
Matt Campbell, who's the former tax counsel,
right?
The finance committee.
But in there, he discusses his proposal, but he also says these 2 pages discussing Rahm Emanuel's proposal.
Yeah.
And to me, that's significant. I think that you've got the Wyden, who is on the Emanuel was on the Ways and Means Committee, or still is, I guess, but will be in a much better position. And I think that with a heavily Democratic Congress and sufficiently heavy Democratic senator, that you're going to see some movement in these areas.
I put the
title of it in the chat box for everyone.
Fine.
It's today's tax
notes.
Right, but it was in the magazine yesterday. Yeah. So we had a lot of current stuff to talk about today.
Yeah.
Which is unusual with these kinds of topics. This one is moving.
In fact, this is a really good summation. Of all the Democratic plans
being put forward.
I agree with you,
Mark. This is going to push forward because
the two influences
are going to be Rangel
and
obviously Emanuel,
Chief of Staff.
It's not like and Obama, just the fact that of what he did with as one of the 3 co-sponsors of the Stop Haven Tax Abuse Act. So I think you're going to see some definite movement in this area. I think the other thing is that you're going to see massive exchange of information and some substantial increase in assistance in collection in the coming couple of years. I think they'll make a much more serious effort. The other thing I would watch out for, just before Clinton left office, almost 8 years ago, his Treasury introduced a proposed regulation. I think I touched on this last week. That would information on all bank accounts owned by foreign persons, and with, of course, a lot of that then being available to be passed on to other countries. I think you're going to see some changes in that area. I would not be. I mean, Bush administration has to keep those proposed regulations from ever being finalized, but I would not be surprised to see those resurrected, either as is now, or which would provide for at least full information for all European Union countries, and they've got their information. But you're just going to see a much broader set of things on all of this now. I think that.
What do you think about UBS? You think that they're going to be denied QI status? You think they're going to get punished?
Well, somebody said that they should. There was an article by Joan Wyden in a couple of days ago, suggesting that.
I'm staring at it right now.
Okay.
And I just assumed that they would lose their QI status, but you're saying they're not. They're not.
Well, I don't know, because actually one of the things they're doing is they've given 1 year QI benefits. I didn't mention at the outset when I talked about the tax information agreement signed yesterday with Liechtenstein. It specifically provides that they get full QI benefits for the year 2009, and that if they proceed as required to ratify this new tax information exchange agreement, so that it takes effect on January 1st, 2010, they will then be granted the normal 6-year extension of QI. So that was something that had previously been done only, I think, with the Bahamas, and is now, it's one of the carrots that they can give that is sort of meaningful to some people. But I think whether or not they go after UBS will depend on the extent to which UBS cooperates. And I see that this TIEA with Liechtenstein may be the link that gets them to agree to cooperate, because they may be able over the next couple of years to begin to collect enough information from Liechtenstein so that they can use that as the wedge to say, well, now there's the like, based on the discussion we had last week, ties together in that way. I guess this is my final lecture in this series, but I'll be doing some more, and I don't know yet, and next fall.
Yes, you have spring, then summer.
Oh yeah, sorry, it's first.
Then
okay,
then next fall.
Yeah, spring.
Yeah, spring first.
Okay, spring then. Okay, whatever. Yeah.
James Curie says, "What's QI?" Looking at tax today.
Qualified intermediary rules.
Means qualified intermediary. Yeah. It's the basis of qualified intermediary. And what UBS was doing originally, as I understand the articles, not that I have inside information, was under QI, You were not forced.
Not required
to turn over the
names of Americans
who may have been
non-compliant with U.S. tax regulations.
However,
this
is the important
however,
you had to certify to the IRS that any such account did not have any U.S. securities. And apparently UBS set up some structures, bank structures, and 20,000 accounts had U.S. securities through whatever the structure was. I don't know. I'm guessing foundations in Liechtenstein, but I don't know. The point was that UBS apparently they have communications that UBS knew that this wasn't compliant. I don't know the inside story and I haven't researched it. But
well, one of the things we have a lot of the information concerning Liechtenstein came from a former employee of one of the Liechtenstein banks who stole the information, sold it to the German government, and apparently to other governments as well. Either that or the German government has resold it to the United States and Australia and other interested countries and collected probably a profit for their ill-gotten gains. But that's dealing with spies. Go on the IRS website. There's a special program now for whistleblowers.
Yeah.
And it's nasty. They get paid. Somebody's asking about the location of my paper 2 years ago. That would be in offshore. Byrnes can download, I guess, and
we actually subscribed
to offshore investment now. I got to follow up the library.
Well, if not, we can.
I don't know how to get in. I don't know our password, but. Anyway, I'll find it.
All right. Well, if you can't get it, just get back to me, and I will get you a copy.
I had the article.
I was going to post
it, but I'd rather the library post the new
get into offshore investment directly.
To get into offshore investment.
Okay.
I just noticed that Twin was.
Twin having a little.
I was in Twin earlier,
sending out emails this morning.
But it
locked me out during your class.
They might be backing
it up.
Yeah, now let me in.
I'll
post it.
I'll post your
article, and I'll get the library to put up the offshore investment link.
Okay.
Well,
thank you. I don't
questions. One
other questions.
Anyone have any other questions? I don't see any.
Now remember Thursday we have our final lecture
for this
class.
Professor
Kleinfeld
is going to be discussing
audit techniques, revenue
audit techniques
internationally.
And
that's Thursday at the same time. 8 till 9 o'clock Pacific, 11 till noon, Miami.
After he finishes, I'll finalize a summation, just to make sure everyone knows which assignments were due, and deadlines, and if anyone needs
extend Professor de Coker or myself.
Okay. No other questions.
Great. Thank you very kindly.
Okay.
Professor Langer, this has been great. And we'll schedule up our spring lectures.
And I'm
sure you want to do those
after
the administration has announced what it's.
Well, they're likely to announce what they want.
Sometime in February.
I believe the typical budget message comes out the first week in February.
Yeah, Yeah, I think so. I think by mid-February,
I'd say by
they'll have
mid-February we'll
all
at least
their
have
bills
some
out.
idea. Yeah. And the course is what in the spring? It's not
offshore financial centers, international offshore financial centers.
Okay.
And that's the one. That's the one for Dennis and you. We'll have George Salas doing software for doing your offshore tax credits, like dealing with all that kind of stuff. Charles Kane will do his normal entity thing on like Isle of Man and hybrids.
Gray,
yada yada. Yeah, Stephen Gray. Yeah, Stephen Gray. I've sent him an email. Email me back. Yeah, I'll follow up with you on that.
Okay. All right.